Good afternoon. Welcome. I am Teresa Miguel Stearns, Associate Dean and Director of our fabulous Daniel F. Cracchiolo Law Library, and it is my distinct pleasure to welcome you to this very special faculty book talk featuring Professor Ned Foley in conversation with Professor Andy Coan to discuss Professor Foley's book, Ballot Battles, second edition, as well as a forthcoming book, which I know you'll talk about, and a variety of other matters related to election law. So Professor Foley is the Charles W. Ebersold and Florence Whitcomb Ebersold Chair in Constitutional Law and Director of the Election Law Program at The Ohio State University Moritz College of Law. He is currently a Guggenheim Fellow, and for the spring 2024 term, he is here with us as a distinguished visitor. Among his many publications is Presidential Elections and Majority Rule in 2020, which explores the long forgotten philosophical premises underlying the post-12th Amendment Electoral College. The second edition of Ballot Battles is due out later this year, as well as a forthcoming book, Common Ground Democracy, Constitutional Principles and Election Procedures. In conversation with Professor Foley is Professor Coan, our Associate Dean for Research, and Milton O. Reep Chair in Constitutional Law and Director of the William H. Rehnquist Center on Constitutional Structures of Government at the University of Arizona, where he teaches constitutional law, federal courts, and related subjects. Professor Coan's scholarly interests include the Supreme Court, federalism, executive power, and constitutional interpretation. In 2019, he received the college's Leslie F. and Patricia Bell Faculty Service Award. He is the author of 2 books and numerous articles, and he joined our law faculty in 2014. And we welcome both Professor Foley and Professor Coan. Thank you so much for joining us. And this is Professor Foley's last day on campus with us, so a very special time to have him here. Thank you both so much.
One more day. I can't believe I'm actually going to say one more day, but wish I was staying longer. But
So do we.
Well, thank you so much, Teresa, and thank you all for coming. Ned actually writes books so quickly that we're actually going to be talking about ballot battles and his new book. What is the current working title of that book?
Common Ground Democracy. It may change, but don't hold your breath on the arrival of the new book. This one is supposed to be, the second edition of this one is out May 10th, so not that long from now. But I suspect the newest book that I'm been working on here will still take a couple more years before we see it.
Well, that's great. We've already seen, or I've already seen a chapter, or a draft chapter from that book, which seems like it's coming along. And all of you can see the cover of Ballot Battles here, but from my vantage point, I can see the truly impressive list of blurbs on the back of this book, including from James McPherson, the leading living historian of the Civil War, and Heather Gerken, the dean of Yale Law School, and Nathaniel Persily, another leading election law scholar. So if you enjoy our conversation today, I highly encourage you to check out this book. Maybe, Ned, you could just start by giving us a brief summary of Ballot Battles.
Sure. So it's the history of fighting over election results in our country from the founding all the way to the present. The first edition ended in 2015, and the second edition takes us up to date. And it turns out, unbeknownst to me until I started the research, that there are a lot of interesting stories. I knew about Bush versus Gore because I remembered that, and that is a modern one to think about, but there's a lot of interesting earlier versions, and studying the history, at least for me, explains some things about why our democracy struggles with certain important aspects of running elections, including settling the outcomes when there's fierce competition.
How did you get interested in contested elections?
We were fortunate enough to start our election law program at Ohio State in 2004. So Bush versus Gore was 2000, and those who lived through that know how searing that was for the country in the field of election law. And I had been teaching election law ever since I started teaching back in 1992. But the election law class had focused on things like campaign finance and redistricting, not so much counting votes. And Bush versus Gore got everybody's attention over the problems associated with vote counting. And the Congress passed a law in 2002 called the Help America Vote Act, which no reason why people in the field would remember that title, but it really actually was very important for how to run elections, including introducing provisional ballots, because of problems that had happened in Florida in 2000. A provisional ballot is when you show up at the polls and the poll workers don't think you're registered, but you think you are registered. You get a provisional ballot, which gets counted if you can prove and they can prove that you were actually a voter. But it's not automatically counted. So the nature of a provisional ballot is it's inherently disputable. You fight about them after election day, and they always get counted, but fighting over them can be really important in really close races. And so in Ohio in 2004, with this brand new federal law and this brand new concept of provisional ballots, that became a focal point if that election was going to be contested the way Florida in 2000 had been. And 2004 ended up being outside the margin of litigation, to use a phrase election lawyers sort of developed at the time. Ohio was the pivotal state, but that was Bush versus Kerry, and Kerry didn't come close enough to really challenging it, although they were prepared to do so. Anyway, I started working on those topics, and around about 2007, I decided I wanted to figure out what were the best practices for recounts when the system is stress tested in the most difficult way. And so that's what I thought it was not going to be a history book. I thought it was going to be a sort of 50-state survey of all the different practices of doing recounts and trying to figure out which state had the best recount rules. But trying to research the topic that way led me to think, no, you have to excavate the history of this, because the laws of recounts, you can't really tell how they're going to perform unless you see them, under stress. So in Florida, if you had asked about Florida's election laws in 1998, you would have thought they were in pretty good shape until hanging chads developed and all sorts of things went wrong. And Minnesota had a US Senate race that was disputed in 2008. Minnesota had pretty good laws in some respect, but their absentee ballot laws weren't perfect. So it turned out that why we have trouble with these intense battles was something that, at least in my mind, needed historical investigation.
Can you give us a couple of examples of contested elections from U.S. history, maybe lesser known examples that might still have some lessons for today?
Sure. So a fun one, I think, of course, I'm nerdy, I guess, but in 1792, so way back at the beginning of the country, New York had a disputed gubernatorial election. And the ballots that were contested were from Cooperstown, New York. There wasn't any Baseball Hall of Fame in Cooperstown at the time, but that's where it was. And all of the founders, or most of the major founders that we look for insight about the nature of our constitutional system, were involved in one way or another in this intensely disputed election. So John Jay was the candidate from the so-called Federalist Party running to be governor of New York. And this was the first election. Remember, they didn't want political parties. They had hoped that they created a system that would avoid permanent political parties instead of just this multiplicity of factions that would change over time. But by 1792, both at the national level and at the New York level, there was the Federalist Party, and John Jay was its candidate for governor, and Alexander Hamilton was sort of effectively his campaign manager. We all know Alexander Hamilton, whether we've seen the musical or not, right? And the opposing party was James Madison and Thomas Jefferson, and they had their own candidate, a guy named George Clinton. But anyway, and so watching this political parties deal with the partisanship in that very first heated election. And the other reason that was interesting to me was, states were really important in our federal system back then, even more so maybe than now. So John Jay at the time was the first Chief Justice of the United States. And he was willing to give up that position to be governor of New York, sort of interesting comparison in terms of the relative importance of the job. And it was an intensely fought election, and there were these ballots from Cooperstown that were contested, and it wasn't hanging chads, but some of the same principles. So each side had a plausible claim based on New York law at the time. And the institution of New York law to resolve this dispute was a canvassing board. And the problem was that the canvassing board had been set up by the legislature, and they had 6 members of the Jeffersonian Party and 3 members of the Federalist Party. So it was lopsided. And on a party line vote, they ruled in favor of Clinton, the Jeffersonian candidate, and against Jay, the Federalist candidate. And there was rioting. Thankfully, there's no deaths, but there was some injuries and some blood, gunshots and blood. I mean, it was a really, and they talked about it a sort of a nascent civil war at the at the state level. And Madison and Jefferson and James Monroe, they're all writing letters about how do we handle this, because they don't really have any principles within their constitutional system to figure out what to do when you've got this kind of intense dispute. And so the fact that they couldn't handle it themselves taught me, at any rate, that they didn't give us the tools. They didn't prepare us for the kinds of disputes that we've and so we're going to have to figure this out on their own, because there's no answer. You know, they didn't have a Garden of Eden that we fell from. I mean, in other words, they were imperfect in this respect. The most interesting insight, I thought, and was a letter. Does the name James Kent mean anything to you? He was a prominent lawyer, judge. He was chancellor of the state of New York, and he wrote commentaries on the U.S. Constitution. So he's sort of a revered figure. And I went to law school in New York, and everybody, James Kent is, you know, this revered guy. Anyway, he's a young member of the Federalist Party. And when he's complaining about the canvassing board stealing, you know, they really thought they were robbed. They said the problem was that the board, they said we need an equally biased tribunal. That's not a term we would use. They were searching for the concept of impartiality, and they realized, you know, that when there was 2 parties, you needed to be equally biased instead of lopsided. And ever since, we've struggled to have an institution that is a suitable institution for these kinds of disputes. So that I'd be happy to share another one, but you're the keeper of the time, so let me know if you want.
Let me just ask you a couple of follow-up questions about this episode. Did the canvassing board have the final authority to resolve this dispute under New York state law?
Correct.
And did any reforms emerge in the aftermath of this election in response to the rioting and what it seems like all parties recognized as an inadequate system for resolving these conflicts?
Yes. So, well, knowing, I mean, so New York law specifically said that there was no judicial review at the time. So it was going to be the canvassing board, this more political body, that would have the last word. And that is something that's changed over time, and that's talked about in the book. And in general, we do better when courts handle these cases than partisan, you know, political bodies do. The other interesting lesson from this example and many others, and it's actually really true about the Help America Vote Act, every time there's a dispute of this nature, it's because there's an ambiguity or a problem in the law running the elections. And the particular details of the problem here were rules about how the local sheriff in Cooperstown was supposed to collect the ballots in secure ballot box and then deliver them to the state canvassing board. And the way in which the sheriff took custody of the ballots and delivered them was kind of shady, and it was unclear whether he was obeying state law or not. And he himself, the local sheriff, was a partisan official, and there might have been some mischief that was done while they were in his custody. And so the way they decided to handle this was to clarify those rules of of election administration. So you couldn't have a sheriff do the particular thing that the sheriff did. And if you think about it, that's what we did after the hanging chads of Bush versus Gore. We didn't say everybody was upset that the U.S. Supreme Court divided 5-4 in a way that looked partisan, and the Florida Supreme Court itself had divided 4-3 in a way that looked partisan. We didn't change those institutions to get that equally biased tribunal. Instead, we said, let's just get rid of hanging chads. And it's good to fix election rules to make them clearer to avoid problems like hanging chads, but that's like whack-a-mole a little bit. It's like you handle the thing that triggered the particular dispute, but there could be some that's why I got interested in provisional ballots after 2000. I was like, oh my goodness, we don't have any more hanging chads, but we've got this brand new thing called provisional ballots, which is well intentioned, but the Help America Vote Act leaves a lot of ambiguity about how they're supposed to be handled. So that's going to be potentially our next fight is going to be over those. They turned out, well, Washington State had an election in 2004 for governor where provisional ballots were part of the dispute, but absentee ballots have been a real focal point of dispute over the last 20 years because we've just relied a lot more on it. So we changed the rules for running elections, but we don't really think about the institution to handle the dispute when it arises. It's like, I use the analogy in the book of the Titanic, because it's like, okay, we're going to build we don't need lifeboats if we have an unsinkable Titanic. So as long as we have all the great rules for casting the votes in the first place, we don't have to worry about the integrity or the impartiality or the legitimacy of the institution that will deal with the problem when it emerges. But you need, in elections, you need lifeboats.
I think we have time for one more example.
So, and this is a sad example, but anyway. So in Kentucky in 1899, another gubernatorial election. By the way, part of the reason why we haven't learned how to handle this is in the United States, we have very important chief executive elections for president and governor. But a lot of our legal system, including a lot of our electoral system, comes from Britain, which is a parliamentary system, right? Parliament, there is never a pressure, or very rarely will the entire partisan control of a legislative chamber turn on a single seat. So the stakes in a legislative disputed election are never as high as the stakes in a chief executive election, whether you're talking national president or state level governor. And so when we inherited our system and had our Declaration of Independence, we inherited the British method of handling disputed legislative elections, which is each legislative chamber is the judge of its own elections, and that can lead to partisan mischief, but it's relatively contained to a single seat. And Britain didn't need to worry about chief executive elections because they have prime ministers or kings, neither which are popularly elected the way we elect governors or presidents. So that's why we have a missing institution and a missing conception of what these things should be handled. So it's not surprising that two of the main examples that I'll give you is this New York gubernatorial election, which very early on exposed this problem. And then in Kentucky in 1899, another gubernatorial election was at the height of another previously hyperpolarized era. The thing that worries me about where we are in American politics right now is our polarization kind of mimics the ugliness of the Gilded Age, which was sort of the 1880s and 1890s. And that's worrisome because there was a lot of political violence in the 1880s and 1890s around elections. And we hope that we don't revisit that in our own times. I mean, we've already unfortunately seen it in January 6th, but let's hope it can be contained because there were many episodes of that nature at the state level in the 1880s and 1890s. And the only time there's been a political assassination over the result of an election was this Kentucky gubernatorial election, where in the midst of fighting over the votes cast, they were in the process of being counted. One of the two candidates was assassinated, and believe it or not, it's hard to believe this, the bullet was fired from the office of the Secretary of State's window. And they never figured out who pulled the trigger. But we worry about partisan secretaries of state with good reason. But that's the low point. And when I asked my students, when I was writing the first edition, I for several years I taught a seminar that was about these episodes, and I would ask the students which was the worst episode. And most years, most students thought that, because there's nothing worse than a political assassination. So that, I mean, again, this is history that I didn't know. They didn't teach me in college or in high school or law school. And I do think you have a better understanding of our nation by looking at the totality of these events, because one of the important things about this Kentucky election is it gets up to the US Supreme Court in a case called Taylor versus Beckham. And it's an 8-1 decision. And the 8-justice majority rejects a 14th Amendment challenge to real mischief that had been done in a partisan way in the process that was so ugly at the state level. And there's a due process claim that says it violates the due process clause to frustrate the will of the voters by essentially fraudulently counting the ballots. And 8 justices of the court cite the political question doctrine and say, we can't touch this as political. And John Marshall Harlan, the first Justice John Marshall Harlan, writes this unbelievably eloquent and passionate dissent. You know, he's known to us as the great dissenter from his dissent in Plessy versus Ferguson, where once again, it was a lone dissent, 8-1, right around the same time period. But I had never heard of Taylor versus Beckham until I started work on the book. So Harlan gets vindicated in Brown versus Board of Education a half century later. And believe it or not, and this you might find a controversial statement, Bush versus Gore, I think, is the vindication of Harlan's dissent, because Bush versus Gore is the first time the US Supreme Court says that the 14th Amendment constrains the way in which state officials count votes so that they don't manipulate votes in an improper way. Now, you may not like how the court did it in Bush versus Gore. My chapter on Bush versus Gore talks about the fact that there's really 2 parts of the case. The first part is a 7-2 ruling on the substance of the 14th Amendment, that hanging chads shouldn't be treated improperly in a partisan way. And then the other part of Bush versus Gore is this 5-4 ruling that refuses to let the state of Florida fix the equal protection 14th Amendment violation and just shuts down the recount. I personally have much more problems with that second part. The position I take in the book is that the 7-2 ruling that the Fourth Amendment has some purchase in this context is actually the position that Harlan took in this Kentucky case, and it took a century for that, constitutional principle to be recognized. Now, Bush versus Gore doesn't cite Taylor versus Beckham. It's too fast a moving litigation. I trace the way in which these kinds of cases get handled in federal courts as well as state courts from 1899 to, I mean, you can really think of Taylor versus Beckham in 1899. Well, actually, the Supreme Court's decision is in 1900. The election was in 1899. But Taylor versus Beckham, 1900, Bush versus Gore, 2000. That's a 100-year period. Those 2 cases bookend what I write as a transformation where we actually, for the most part, take these disputes out of partisan realms where violence occurred a lot in the 19th century, put them, for the most part, in the judicial realm. And the way in which our country handles these disputes in the 20th century is much better than in the 19th century. And what worries me today is, are we backsliding? And the second, we can talk about this if you want, but the second edition is more pessimistic. I had hoped that Bush versus Gore and the use of the courts to settle these things and the use of the federal courts as well as state courts would actually mean that the 21st century would indicate even more progress in this realm than the progress we made from 19th to 20th. I worry that our progress has stalled and maybe even reversed itself, but Anyway.
I want to get to those questions, but before we do, I have a couple of follow-up questions about this Kentucky example from 1899. Is the impact of the Supreme Court, the practical effect of the Supreme Court's ruling in this case, to leave in place a ruling by the Kentucky State Supreme Court?
Correct.
And what was that ruling, and what were the practical effects on the ground of leaving it in place?
Well, the practical effect was, one was bitter, this incredible bitterness at the state level where one side really felt that the election had been robbed from them and that they got no recourse from the judiciary to kind of protect the integrity of the voting process. So one meta theme that's in the introduction of the book is what should be our attitude to these kinds of disputes. So interesting enough, Alexander Hamilton, in his role of advising John Jay, says, look, you were robbed and you have grounds for complaint, but the proper response, instead of really fighting this in the streets, there was no judicial recourse back then, is just walk away from it and run 3 years later, New York having to be 3 years rotation for governor's at the time, and just win again. And Jay did that. He came back, ran again, and clobbered the opponent the next time. And so the Hamiltonian view in this is, elections are going to get stolen. They're not always going to be fair, but as long as there's the capacity to win big next time. The problem, Hamilton wrote a letter to Jay, said the problem is you didn't win by a large enough margin. So you couldn't claim that it was beyond the capacity to steal it in the vote counting process. So we just win big next time and we'll be fine. And that's what happened. Interestingly enough, James Madison, Hamilton's partner in the Federalist Papers, has a totally different attitude about these sorts of issues. He's more of a purist. He says, no. Every election needs to have a right answer and a fair result, and it's our job to figure out what the right answer is. So, ultimately, in Kentucky in 1899, the losing party kind of went home. Again, there was a lot of ugliness, including this awful assassination, but the state survived to run an election, 4 years later.
Do you think the U.S. Supreme Court would have had greater legitimacy to resolve this conflict in a way that was peaceful and accepted by all sides than the Kentucky Supreme Court did?
Well, the ruling of the Kentucky Supreme Court was not on the merits. It was the state version of the political question document. I mean, the state constitutional law vested the power to count the votes in the legislature. This was a rule, again, if you think about how Parliament counts votes for parliamentary elections in Britain, each chamber of our legislatures counts votes for those offices. Legislatures early on in American history exercised the prerogative that they would count the votes in gubernatorial elections also. In the New York case, it was the legislature that set up the partisan canvassing board that acted partisan, and that's similar to what happened in Kentucky. So one party happened to be in control of the legislature, and it was seen as a partisan count that wasn't fair. And the Kentucky Supreme Court said, no judicial jurisdiction here. The state constitution says this belongs to legislative prerogative. So it wasn't like the U.S. Supreme Court was saying Kentucky's judicial interpretation of Kentucky law was better than our. It was whether judicial enforcement of the 14th Amendment was going to constrain the state's ability to invest this in a partisan body that achieves ostensibly partisan results.
Yeah, that makes a lot of sense. So it sounds like one really important set of problems in this 1899 election and in the earlier context, the New York State gubernatorial election was institutional, but that polarization also played a pretty big role, at least in the 1899 episode. How did that end up that political polarization that roiled the country during the Gilded Era, how did that work itself out? And is there any reason for optimism that it might give us today, or any lessons that we might draw today about how to solve that aspect or to address that aspect of these problems?
So the answer is yes. The progressive era was a corrective to the problem of the Gilded Age and polarization. And there's a chapter on the progressive, and the progressive era does improve this domain. And in fact, we come back to New York in the progressive era chapter for Governor Charles Evans Hughes at the time insists that there are going to be fair recounts in the state of New York, and so there's a modicum of forward momentum that begins the 20th century. There's another book that I've been planning to write and haven't written yet, and you guys can tell me what I was going to write a book about the progressive era itself and how it followed from the Gilded Age as a way to learn to think that we, the United States, now need a neo-progressive era, because, as many people say, we're living in a neo-Gilded Age with wealth disparity, polarization, and so forth. And the progressive era was this incredibly fertile period of electoral reform. Not in every dimension, was really bad on race relations, unfortunately, but we got women's suffrage, we got direct election of US senators, so we were actually capable of mending the Constitution for electoral reform in really significant ways. We got the secret ballot, we got partisan primaries, where you like them or not, we got initiatives in referendum, the direct democracy. We got a lot of election reform in the progressive era. So I wanted to do a deep dive. If you think of this book as all of it's the entirety of the timeline of American history from founding to the president on one slice of election law recounts. The progressive era book was going to be a single time slice, the progressive era on all dimensions of electoral reform, to try to understand it from that way. And I've still got a lot of research underway, but then after the 2016 presidential election and trying to figure out what happened there, I felt compelled to write the book on the 12th Amendment and the Electoral College, because we had to understand, as I had to understand, what went wrong in 2016. And that was not a partisan point. It was, and this is probably a separate conversation, but the key thing to understand about the 2016 election is Trump was able to win a majority of electoral votes when 1/3 of the electoral votes were won in states where he was under 50% in the popular vote. And he gets 101 electoral votes from states where he's sub 50%, and he wins 304 electoral votes. So, and I had known enough about the 12th Amendment, which requires you to win a majority of electoral votes, so they really cared about majority wins, not sub 50% plurality wins. And I said, so how do we get a result that seems so inconsistent with the framing of the 12th Amendment? And that was that other book. But we're not talking about that book today. And so now I'm writing this new book that we haven't talked about. And so this book about the history of the progressive era is still somewhere on hold, that I hope I've gotten mixed reaction from colleagues. Heather Gerken said, you've got to write this progressive era book. We desperately need that. Other people said the history of the progressive era will still be there, and there are these other more urgent problems that you have to solve. So I can only write one book at a time, I guess.
Well, I think this is a nice point for us to transition to the new book. I have lots more questions about the lessons of these historical episodes for our present day electoral system. But I wonder if you could just start us out on this new topic by providing a summary of what you hope to say in this new book, or the issues that you hope to discuss.
Yeah, so the new book is about, the new book is in some ways an extension of the 12th Amendment presidential elections book, but applying to all elections. And it relates to this issue of majority winner votes. Most Americans think that the way we vote is whoever gets a majority wins. But in fact, the distinction mathematically between a plurality and a majority is plurality just means more than anybody else. And if you have 3 or more candidates, you can have a plurality without a majority, and that means there's fragmentation in the result. And that becomes quite difficult to figure out what the right answer is if the electorate is fragmented in that way, and that can happen under conditions of polarization. So the new book is trying to basically say, given a set of election inputs from the voters, if this is what the voters tell us that they want, what is the right outcome? And it turns out that's a challenge, both philosophically as a matter of democratic theory and mathematically in terms of taking again, if there are only 2 candidates, pretty straightforward, whoever gets the most votes wins because that's a majority. But when there's 3 or more candidates, getting to the right answer is tricky. So the book is designed to address that and to address it in relationship to constitutional principles, to say that we live in a constitutional system that's built on things like separation of powers, federalism, judicial protection of individual rights so that we don't have a tyranny of the majority. And so the question that this book is designed to address is that what is the right understanding of elections in the constitutional system that we currently have?
As I understand it, this new book is going to talk a fair amount about social choice theory. Can you tell us what social choice theory is and who the Marquis de Condorcet was?
So yeah, social choice theory is sort of the term that a group of academics used to address this problem of the relationship between inputs and outputs. And it's also what interested James Madison in the Federalist Papers, the founders, right? I mean, the idea here is we know in a free society there's going to be a variety of opinions on government policy. And the Madisonian project was, how do you take that variety of inputs and perspectives and achieve the common good or public policy in the public interest? And Madison and sort of Madisonian theory handles that largely through checks and balances and separation of powers, a sort of divide and conquer, right? Where we don't want one institution of government to have too much control because that is dangerous. And we hope that this competition on checks and balances, ambition counteracting ambition, will find its way to the collective good. And there's a lot of value and insight to that approach. And it was an effort of the Enlightenment to apply the faculty of human reason to figure out how to do government better on the behalf of the public. While that was happening in our country here, across the Atlantic, a French philosopher, the Marquis de Condorcet, was tackling the same problem with somewhat different ideas. I mean, again, trying to apply the faculty of the mind and human reason just to address the same issue. But he sort of approached this much more mathematically and in the context of electoral choice. And so he said, for a given set of inputs, how do we get the right output? And so he sometimes thought of as the founder of modern social choice, because much of the work that's been done since Condorcet wrote about this in the 1880s, 1870s, 1880s, is efforts to refine and improve the mathematics of electoral choice, which again, I'm not going to get on draw these complicated equations because we don't want to do that, but there is some tricky math involved, unfortunately.
One of the interesting and timely proposals in your book is a top 3 presidential election system. I think you could apply this top 3 system not just to presidential elections, but other elections too. Can you explain what that is and what problem it's intended to solve?
Yeah. So I think all of us who are following the presidential election know it's a rematch between Biden and Trump, and we hear all these people in news commentaries that many Americans would like some other option, and we just don't want a repeat of the last election, but that's what we're getting. And so what a top three system would do would, instead of just having one vote that voters would have, do you prefer Biden or Trump? There would be three candidates, and you would vote three times between each pair of candidates. So, who that third candidate would be would emerge in the context of the top three system. There would need to be a preliminary vote that would yield three finalists. If you're familiar with the California top two electoral system that they use for their Senate race, for example, all the candidates are on the ballot in a nonpartisan primary, and they send two on. You could have a top three version of this. And, Nikki Haley tried to be a third candidate, but inside the, Republican primary, and that didn't work. Joe Manchin gave up. But so it doesn't really matter who that third candidate is. Just imagine there's some third candidate. The top three system would, and I'll pick Chris Christie because I actually heard over the weekend that he's still thinking about a third party run. I don't know if that's a great idea, but given that our system can't really handle it, but he was on David Axelrod's most recent podcast saying he wasn't going to rule out a third party bid this year. Anyway, so just using him as an example, a top three system would mean you would vote Biden versus Christie versus Trump, Biden versus Trump. So you'd vote all three choices, and the winner would be the candidate who beat the other two competitors one-on-one or head-to-head. And until it happens, you don't know who that winner is. But there's reasons in context of polarization to think that maybe that third option can beat the other two, because Biden voters prefer Christie to Trump and Trump voters prefer Christie to Biden. And the problem that we have is if you have all three candidates on the ballot at the same time, nobody's going to get to that 50%, right? We are now a 40-20-40 country, right? We've got 40%, and you guys in Arizona, right, are seeing. You've made the point this applies to not just presidential elections. I mean, it looked like for a while there might be a three-way race, but for U.S. Senate here, that would have been going into it roughly again a 40-20-40 split. You could play around with those numbers. The system can't handle that, and now it's going to be a two candidate race. So the top three system is designed to give room for that third choice and define what is the most sensible outcome given the division, this three-way division that exists in society.
Why do you think the most sensible outcome in these circumstances is for that middle candidate, that 20 candidate, who is the first choice of only a small fraction of the country to prevail in one of these elections?
Well, this is why this is a philosophical issue and not a mathematical issue. And this is what, and I welcome feedback and input by email or, conversations, because what do you do if, 40% really want one thing, and when they really don't want what the other 40% want? And, this 40% thinks they're right, but really hates the other 40%. I mean, and the tribalism of current American politics, right? Where the enmity on both sides for the opposite side. So we have a choice. We could elect in that kind of three-way split somebody who gets 40 to 45% of the vote. But what that means is the 55 to 60% really don't want that outcome. And that's true whether or not, the blue wins or red wins. Like blue doesn't want red to win, red doesn't want blue to win. Now you could say, well, they both don't want purple to win, right? So they agree on that. On the other hand, the purple is a kind of a reluctant compromise. I mean, the thing about compromising is it's always not fully satisfying, right? Because by definition, a compromise is all right, but maybe we can depolarize and get back to more common ground. That's why the tentative title is Common Ground Democracy. If we could say, all right, we need to pick one winner for this kind of office. You know, the other offices may be able to do through proportional representation or something, but for president or senator or governor, there's got to be one person to represent all of us. So who is the one person to represent all of us when we're divided in this way? The philosophical claim that I hope to bring forward in the book is that there's no perfect system, but it's better to try to find that, and it's more in keeping with the concept of Madisonian principles that we've inherited, that we're looking for a majority answer that is most protective of minority rights and minority interests. So picking that purple candidate in the middle, that's the second choice of both red and blue, is going to make fewer people unhappy with the outcome, even if it's not the first choice of as many people. And so having a governor or US senator who comes from that common ground space on balance is going to be better. And it's not just better representation, you're actually in Congress, given separation of powers, and you're going to get better outcomes, because right now Congress is, you know, has a hard time with the budget, right? Our gridlock and all this kind of stuff. Our polarization has led to dysfunctionality of government. And if we could get more folks closer to that common ground, we're more likely to have compromised legislative solutions as well as compromised electoral results.
Is there any jurisdiction in the US that has implemented this approach, or elsewhere for that matter, that's implemented this approach, which can give us some sense of how it works in practice?
No, I mean, candidly, somebody's got to be the bold. I mean, so there's some private organizations, apparently, I mean, I haven't done a survey but apparently there's a bunch of faculty governance at various universities around the country in different kinds of departments that do Condorcet elections. It was actually first invented before Condorcet in the 13th century by a Majorcan monk named Raymond Lull, who invented it to elect the head prelate of the monastery on the island of Majorca. But that was lost to history until his papers were discovered in a different monastery in Germany. So Condorcet gets all the credit when in fact it was originally invented in 1260 something. But no, I mean, the pre-computers with lots of voters, it would be tricky. I mean, when you think about the fact that ranked choice voting is relatively new, you can do a variation of ranked choice voting to achieve Condorcet results if you want to use ranked ballots. So I think the fact that it hasn't been adopted, while a cautionary tale, is also a product of technology. And the great thing about American federalism is we could have experimentation, right? And in fact, you guys in Arizona, there's a movement of an organization to gather signatures for a ballot initiative so that they get enough signatures by July. It'll go on the ballot in November. And without getting into the details too much, it is agnostic as between a Condorcet method of ranked choice voting and a non-Condorcet method. So Arizona could be the leader in the country of exploring whether or not a common ground democracy system could actually work.
So there's room for experimentation at the state level, but what about the presidential level? What would it take to implement this at the presidential level?
Well, it could be a constitutional amendment, which is really difficult, could do it. Have you all heard of something called the National Popular Vote Interstate? Who's heard of the National Popular Vote? Who has not heard of it? Don't be embarrassed. It's not being done. Okay, so real quick, because I know we're running out of time. The concept of the compact is if enough states that you have to have 270 electoral votes to be the winner of the Electoral College. And right now, each state does its own thing in terms of electoral votes. But if states with 270 or more electoral votes pooled their electoral votes, they would control the outcome. So the current version of this compact, which has about 200 electoral votes on board, but not yet 270, would simply turn the presidential election over to the winner of the national popular vote, all 50 states, but a plurality winner, not a majority winner. So, Robert Kennedy, if he's a spoiler, could spoil the result under the compact idea. But my modification of the compact idea is if states with 270 electoral votes adopted this top three system amongst themselves, they could control the winner of the presidency among their collective electoral votes. So you could do it that way without a constitutional amendment.
Okay, I think we're out of time, Teresa.
We are. Thank you so much. This has been so interesting. Please join me and thank you, Professor Foley.
Thank you for having me. And by the way, can I just, as a personal point, thank you so much to Teresa, Andy, all of you. Everybody has been so nice and kind to me on my visit here. It's just been a pleasure to be amongst you and to get to know you and to be here. So thank you for your warmth and generosity. Likewise.
Thank you for coming, everyone.